At the end of the previous episode, I raised the question, why is the death penalty imposed for so many sexual offenses? As I explained, in the law, the death penalty indicates that the offense has life or death implications. As I believe Unwin's work aptly demonstrates, sexuality has just such consequences for entire civilizations. It takes great sexual discipline both to build and to preserve civilizations, and sexual discipline means restricting sexual opportunity to strict monogamy. The sexual practices punishable by death are destructive of civilizations, especially by virtue of expanding sexual opportunity, which is not turned in the direction of marriage and family, and turns away from activities which build and maintain civilization. And because these practices result in death on a civilizational level, they're punishable by death. I then briefly addressed the question, how should such sins be censured in Christendom? Should they still be punishable by death? Thinking of Christendom as a civilization with a supporting culture that, under the influence of traditional Christianity, orients its members toward the kingdom of heaven, a definition, I'll remind you, I have borrowed from John Strickland. If we were to talk meaningfully of Christendom as a civilization, then we do have somehow to insist on a strict sexual discipline, including prenuptial chastity and absolute monogamy. This standard requires some means of enforcement which result in a high price for non-compliance. I concluded that episode with brief consideration of an argument for the imposition of the death penalty, which is the pedagogical role of the law. That is, the law, both by prohibiting and punishing, leads us to Christ. In this episode, I intend to lay out in broad strokes my conception of the philosophy of law which, on my view, is most consistent with the goal of Christendom, which, consistent with the pedagogical role of the law leading us to Christ, is to point people to the kingdom of heaven. Christendom is a civilization with a culture influenced by historic Christianity. Christendom is not the kingdom of heaven brought to earth by human effort. Christendom is not a Christian nation. Of course, a civilization with a culture influenced by historic Christianity will have a body of law also influenced by historic Christianity. And that body of law will be pedagogical, leading the members of this civilization to Christ. As in the previous episode, I want to look again at the uses of the law according to my confessional standards. And according to those standards, the law is useful in the following ways. 1. For Christians, as a rule of life, it informs us of our duty to God. It directs and binds us to walk accordingly. It shows us the sinful pollutions of our nature, our hearts, and our lives. As we examine ourselves in terms of the law, we might come to further conviction of our sins and of our need for Christ and the perfection of His obedience. 2. For non-Christians, it can be of use in restraining corruption in that it forbids sin and serves to show what sins deserve and what afflictions in this life they can expect for those sins. But also, the promises in the law demonstrate God's approval of obedience and what blessings they, that is, non-Christians, can expect for obedience. Now, on the view of those standards, these uses of the law do not conflict with the grace of the gospel, but comply with the Spirit of Christ. That is, these uses of the law subdue the will and enable it to do freely, even cheerfully, what the will of God, revealed in the law, requires us to do. The spirit of the law is reconciliation and restoration, not punishment, except, as I've mentioned, when the offense involves life and death issues. And yes, in referring to the spirit of the law I'm talking about is the law of Moses. And one of the first things one notices about the law is the focus on restoration and reconciliation. Let me read from Leviticus chapter 6, picking up at verse 1. Then the Lord spoke to Moses, saying, when a person sins and acts unfaithfully against the Lord and deceives his companion in regard to a deposit or a security entrusted to him, or through robbery, or if he has extorted from his companion, or has found what was lost and lied about it and sworn falsely, so that he sins in regard to any one of the things a man may do, then it shall be when he sins and becomes guilty, that he shall restore what he took by robbery, or what he got by extortion, or the deposit which was entrusted to him, or the lost thing which he found, or anything about which he swore falsely. He shall make restitution for it in full, and add to it 1/5 more. He shall give it to the one to whom it belongs on the day he presents his guilt offering. Then he shall bring to the priest his guilt offering to the Lord, a ram without defect from the flock, according to your valuation, for a guilt offering. And the priest shall make atonement for him before the Lord, and he will be forgiven any one of the things which he may have done to incur guilt." Unquote. In this passage, the guilty party is to make the sort of restitution required by the law, first by restoring the stolen item, if, for example, the offense was theft, plus an additional 1/5 of the value as punitive damages. Second, the offender is to proceed to the temple and present his guilt offering. The reason here is simple. Restoration to the injured party does not remove what we would call the stain of guilt. The guilt, particularly the guilt involved in offending God himself by offending one's neighbor, must be atoned. That is to say, the injury against one's neighbor is repaired by restoration plus punitive damages, but the injury against God is repaired by an offering presented to God's priest. Furthermore, after the injuries to God and neighbor are repaired, the law has nothing further to say to the offender. More than that, no one else has anything to say either. He is not to have his offense thrown at him any time someone wishes to do so for any reason, even, or perhaps especially, the injured party. Damages have been paid to the injured party, atonement has been made before God, and that is the end of it, forever. Note something else relevant to these times. The state is never the injured party in these proceedings. In fact, the state, or any governing authority under the law, is never the injured party, not even in the criminal process. There are only two injured parties, one's neighbor and one's God. At best, the state is a referee, or a judge between the parties. If a governing authority presents itself as an, or even the, injured party, then that governing authority presents itself as God. And here, let me refer you back to my episodes titled Enemies of the State and Minister of God. The role of the temple service in healing the relation between the offender and the injured parties, including God, reminds me of something G.K. Chesterton wrote in his little book titled Orthodoxy. Quote, "Morality did not begin by one man saying to another, 'I will not hit you if you do not hit me.' There is no trace of such a transaction. There is a trace of both men having said, 'We must not hit each other in the holy place.' They gained their morality by guarding their religion. They did not cultivate courage. They fought for the shrine and found they had become courageous. They did not cultivate cleanliness. They purified themselves for the altar and found that they were clean." End quote. I think anyone who studies the law of Moses, especially Leviticus, can see how insightful Chesterton is on this issue. Now then, in positioning my view on the approach to crime and restoration I think a reclaimed Christendom should take, I'm going to borrow at length from my denomination's Book of Church Order, not because, as I've said, Christendom is the church or anything like that, but because the Book of Church Order employs a philosophy of law, if you will, and I believe that philosophy of law is the correct approach to civil and criminal affairs in a reclaimed Christendom. In the legal philosophy I believe a reclaimed Christendom should have, legal censures, that is, punitive measures, are an exercise of authority granted to governing authorities by God, in accordance with Romans chapter 13, verses 1 through 4, and have as their purpose to instruct and guide a civilization's members and to promote their welfare. And censure has two senses. One, which refers to the guardianship and control which the governing authorities in a civilization maintain over its members, officers, and courts. Two, one in which the restricted and technical sense, referring specifically to judicial process. In its purest form, censure maintains respect for God and his laws, the good of the civilization, and, I think we should say above all else, the keeping and reclaiming of the disobedient. In Christendom, censure, influenced by the pedagogical role of the law, demands a self-examination. As a judicial action, it is intended to rebuke offenses, remove scandal, promote the health of the civilization, as well as the spiritual good of offenders themselves by pointing them to Jesus Christ. The power of the governing authorities is for building up, not for destruction, exercised as a dispensation of mercy, not wrath. Now, given that, on my view, a reclaimed Christendom will employ some version of theonomy, I need to discuss in at least outline form what that version looks like. In his 2000 book, Rethinking Christ and Culture, a Post-Christendom Perspective, Craig Carter distinguishes types of approaches to Christ and culture, two of which are relevant here, Type 3 and Type 4. I'm quoting now. Both types view Jesus Christ as Lord of the cosmos. Both of them view Jesus as Lord of the whole creation, not just of the church. For both types, the reason why Christians legitimately can ask the wider society to adopt Christian morality is that Jesus is Lord. He rules now at the right hand of the Father, and someday he will return to earth to set up the kingdom in its fullness. At that time, every knee will bow and every tongue will confess that Jesus Christ is Lord, to the glory of God the Father. For both types, there is thus a tension between Christ and the powers of this world at the present time. He claims to be Lord, but they do not recognize his claim. The biggest difference between the two types is that Type 3 holds that, since Jesus is the rightful Lord of this earth, it is therefore legitimate to implement that lordship by violent coercion, if necessary. The reasoning is that since this is what is going to happen in the second coming, we should do it if we gain enough temporal power to do so. Type 4, however, while agreeing that Jesus will use coercion to establish his lordship in the second coming, disagrees with the further step of saying that we should do this in anticipation of the apocalyptic intervention in history by God. Type 4 says that we are not God, and that we should not trust ourselves to use violence. It is not our calling. Our calling is to witness to the gospel of Jesus Christ. His calling is to be the Lord of the cosmos, and when he returns, he will do what only he can do with perfect justice. And that's from pages 192 and 193 of his book, Rethinking Christ and Culture. Now, needless to say, Type 3 expresses the version of Christian theonomy with which most people are familiar, and it is this approach that I reject, and is why I do not consider myself a theonomist, at least as the term is popularly understood. It is one thing to define Christendom as a civilization which points to the kingdom of God, as I do, and quite another to claim it as a civilization in which the lordship of Christ is implemented as some sort of adumbration of the kingdom of Christ, which he will install at his coming. The purpose of a Christian legal system under Christendom is not to implement the lordship of Christ, but rather, even for the few crimes requiring the death penalty, to reclaim and to restore. And this is not a selective application of the law, but the law itself. When we look at legal provisions not punishable by death, we find a system of law functioning more as common law, intended not so much to punish, but to heal relationships, including not just the relationship between parties in a dispute, but between the offender and his God. The death penalty, as I pointed out in the previous episode, is reserved for offenses having life and death implications, and not just for individuals, but for entire civilizations. And since the strict application of the Mosaic law expired with the nation within which it was operable, that is, ancient Israel, we shall have to look elsewhere to learn about those offenses for which the death penalty is imposed. And by elsewhere, I mean God's covenant with Noah and his descendants, namely, all of us, which is a law as much as the law of Moses is. In Genesis chapter 9, verses 6 and 7, God says, "Whoever sheds man's blood, by man his blood shall be shed. For in the image of God he made mankind. As for you, be fruitful and multiply. Populate the earth abundantly, and multiply in it." Here, God requires the taking of a life for a life. In the context of affirming the continuation of human life, the command to populate the earth. The death penalty is connected with the command to be fruitful and multiply. The chief consideration is the preservation of human life. Of course, one question which just has to come up is, to what extent do we exact life for life? Do we make allowances based on extenuating circumstances, such as intent? We can get a clue by looking at the first recorded instance of one man shedding another man's blood, the killing of Abel by his brother Cain, which was intentional, premeditated, and committed with malice aforethought. And, consistent with the Christian view of the continuing role of the law, we learn that God makes distinctions when it comes to killing, distinctions which take into account the ambient circumstances and distinguish premeditated murder from manslaughter, both voluntary and involuntary, and accidental deaths, among others. So here in the Noahic law, only murder is punishable by death. Now, unlike the Mosaic, offenses like adultery and homosexuality are not. So the question which rises is, how should offenses such as these be censured? Offenses which, as I observed previously, have life or death consequences for civilizations. First, there must be an agreement that these acts must be censured in some way, severely even. Second, the censure should be such that violations count as acceptance of the censure. Now let's take a few examples from the law, beginning with premarital sexual intercourse, where it is understood that the intercourse was consensual. The form of the censure would be that the act initiates what we might call common law marriage, and that divorce, except for extremes such as spousal abuse, would never be permitted, not even for adultery. And here's why. This precludes one spouse from committing adultery with the intention of manipulating the other spouse into divorcing him or her. Now, that might seem exceedingly harsh towards the one who is cheated on, but let's recall that in this legal system, both parties understand the consequences for fornication. And, for the record, this includes any sexual activity with or without vaginal penetration. Now let's move to adultery. I think the penalty should be something like a form of death. The first thing is the permissibility of divorce if the fact of adultery is proven in court. The second thing is the severity of the terms of divorce. I would have courts favor the offended spouse in all regards, especially custody of the children. It should be a principle of family law that an adulterous spouse knows he or she is tacitly surrendering parental rights by committing adultery. The third thing is disposition of property. Again, I would have the courts favor the offended party in the disposition of the marital community property, the offending party having uncontested possession of separate property. On this note, I would have it as a requirement in the law that separate property be recorded prior to marriage. The reason for this is to prevent hurt feelings should one spouse ask for this. If it is a matter of law, then it's done, no feelings harmed. This might make it necessary for the courts to determine what subsequently acquired properties are separate as opposed to community. Finally, as far as my own summary of these matters, there should be a tremendous social cost. Adultery is a destructive act. It is destructive not just of families, but of societies and civilizations, and the consequences should reflect that. If I were to sum up the social cost, two words come to mind: cancel culture. What I'm really talking about is mostly just social ostracization. The offending party must be made to suffer shame. But having said that, only for a term of some years, 3 to 7 perhaps. The life of the adulterer or adulteress must be hard, not only as a penalty, but as a warning to others. Having said all that, since we are talking about a reclaimed Christendom, the first step of the process should be an attempt at reconciliation. I would have courts first issue a separation order to allow couples to enter into court-mandated counseling. Adultery is destructive, but so is divorce, and long-term it is better for children and society if marriages can be repaired. If, when the court-decreed counseling is completed, the offended party insists on proceeding with divorce, then the process continues in that direction. Before moving on, I need to point out that the best way to deal with adultery and other sexual sins is prevention. Christian sexual morality begins long before marriage and, so we're clear, is much more than abstinence. Adultery and other sexual sins don't just happen. Chastity is as much a part of an entire way of life as physical fitness, a way of life which can protect a marriage if lived consistently and faithfully. The Westminster Larger Catechism, discussing the prohibition of adultery, which is the 7th commandment, does so in terms of duties required and sins forbidden. As duties required, the Catechism includes chastity in body, mind, affections, words, and behavior. Also included as duties are the preservation of chastity not only in ourselves, but others, watchfulness over our eyes and other senses, temperance, also minding the company we keep, modesty in our apparel. These probably make sense, but the Catechism also adds diligent labor in our callings, the idea being that idleness leaves time and opportunities which might not otherwise present themselves. As sins forbidden, the Catechism includes the obvious ones like adultery, fornication, rape, incest, sodomy, unnatural lusts, unclean imaginations, thoughts, purposes, and affections, as well as all corrupt or filthy communications, wanton looks, immodest apparel, entangling vows of single life, undue delay of marriage, idleness, gluttony, drunkenness, unchaste company, lascivious songs, books, pictures, dancings, movies, and television shows, and all other provocations to or acts of uncleanness, either in ourselves or others. So Christendom, as a civilization with a supporting culture influenced by traditional Christianity, would be a civilization which supports and encourages the sort of lifestyle described here. But the law isn't all about punishment. Much of the law is about restitution, that is, repairing harms. Thieves, for example, are not punished, not as we understand the term anyway. There are no provisions in the law for prisons. The censure for stealing, in any form, is the restoration of the stolen goods and punitive damages of 20%, which does much more for the victim and for society as a whole than locking up the offender for a term of years having little to do with the nature of the offense. I want to take just a single example from the law by way of demonstration, from Exodus chapter 22, verses 1 through 15. Quoting, "If someone steals an ox or a sheep and slaughters it or sells it, he shall pay 5 oxen for the ox and 4 sheep for the sheep. If the thief is caught while breaking in and is struck so that he dies, there will be no guilt for bloodshed on his account. If the sun has risen on him, there will be guilt for bloodshed on his account. A thief shall certainly make restitution. If he owns nothing, then he shall be sold for his theft. If what he stole is actually found alive in his possession, whether an ox or a donkey or a sheep, he shall pay double. If someone lets a field or vineyard be grazed bare, and lets his animal loose so that it grazes in another person's field, he shall make restitution from the best of his own field and the best of his own vineyard. If a fire breaks out and spreads to thorn bushes and stacked grain, or the standing grain, or the field itself is consumed, the one who started the fire must make restitution. If someone gives his neighbor money or goods to keep for him, and it is stolen from the neighbor's house, if the thief is caught, then the thief shall pay double. If the thief is not caught, then the owner of the house shall appear before the judges to determine whether he laid his hands on his neighbor's property. For every breach of trust, whether it is for ox, for donkey, for sheep, for clothing, or for any lost thing about which one says, 'This is it,' the case of both parties shall come before the judges. He whom the judges condemn shall pay double to his neighbor. If someone gives his neighbor a donkey, an ox, a sheep, or any animal to keep for him, and it dies or is insured or driven away while no one is looking, an oath before the Lord shall be taken by the two of them that he has not laid a hand on his neighbor's property, and its owner shall accept it, and he shall not be compelled to make restitution. But if it is actually stolen from him, he shall make restitution to its owner. If it is all torn to pieces, have him bring it as evidence. He shall not be compelled to make restitution for what has been torn to pieces. And if someone borrows an animal from his neighbor, and it is injured or dies while its owner is not with it, he shall make full restitution. If its owner is with it, the borrower shall not be compelled to make restitution. If it is hired, it came by its hire." End quote. We note here that the concern is for restoration of property and the payment of punitive damages in accordance with some valuation. 5 oxen for the theft of a single ox, 4 sheep for the theft of a single sheep. But also taken into consideration are the circumstances under which property is harmed. First, a distinction between theft in broad daylight and breaking and entering at night. One who breaks in at night may be physically assaulted by the property owner, because if a property owner is awakened during the night and learns there is an intruder, he doesn't know what the intruder intends and, for the sake of his family, is not obligated to wait and find out the hard way. So, as the law says, the homeowner incurs no guilt for assaulting an intruder at night, and things are different in broad daylight. The law also takes into account damage to property that does not involve theft, as for example an animal that gets loose and grazes on another man's land because the owner foolishly allowed his livestock to graze his own field bare. Then, too, damage to crops and fields due to fire, as well as damage to property held in trust. Unlike the operation of our legal system, theft and other damage to property are treated as torts, assuming a set of duties or obligations one to another, the claim of a breach of these obligations, whether by overt act or failure to perform an act, which breach caused the damage to the property. These are not matters of criminal law. Other passages in the law treating physical harm, except in the cases of murder or manslaughter, are also treated as matters of tort law. Before moving on, I want to insert a parenthetical observation. As I was composing the script for this episode, I came across a story coming out of Tennessee. A proposed law, House Bill 1834, also known as Bentley's Law, will, if passed, require anyone convicted of vehicular homicide due to intoxication to pay child support if the victim is a parent of minor children. This sort of approach to law is thoroughly consistent with the spirit of the Mosaic Law, a preference for restitution rather than punishment. Now then, one of the important things about the law is that God is also an offended party, and the law provides for the restoration of the relationship with God. Quoting now from Leviticus chapter 6. Then the Lord spoke to Moses, saying, when a person sins and acts unfaithfully against the Lord, and deceives his companion in regard to a deposit or security entrusted to him, or through robbery, or if he has extorted from his companion, or has found what was lost and lied about it and sworn falsely so that he sins in regard to any one of the things a man may do, then it shall be when he sins and becomes guilty, that he shall restore what he took by robbery, or what he got by extortion, or the deposit which was entrusted to him, or the lost thing which he found, or anything about which he swore falsely. He shall make restitution for it in full, and add to it 1/5 more. He shall give to the one to whom it belongs on the day he presents his guilt offering. Then he shall bring to the priest his guilt offering to the Lord, a ram without defect from the flock, according to your valuation, for a guilt offering. And the priest shall make atonement for him before the Lord, and he will be forgiven for any one of the things which he may have done to incur guilt." End quote. Well, that was verses 1 through 7. In this provision, the offender makes restitution to the person he has harmed. Then he proceeds to the temple to make an offering to God for an atonement for the sin he committed against God in sinning against his neighbor. The fact that God is a party to the dispute means that the state, in a reclaimed Christendom, would not be a party to the dispute. No proceeding at law would be styled the state versus John Doe. The state is not an injured party. The state's role is to establish guilt and, if required, to punish or censure the offender. On a biblical view of these matters, the only way that the state can be a party to a dispute is if the state is divine, as if the state is God. The state is God's servant, as Paul explains in Romans chapter 13, verses 1 through 4. Now, a final observation about the law and order in the law of Moses. For all the offenses one finds in the Bible, including the sexual, there is no enforcement arm. There is no one tasked with going around making sure the laws are obeyed. Nothing happens in court until an offended party petitions the court. In a legal scheme like this, an offended party would file a complaint with a court, which would then dispatch officers to investigate, locate, and charge the offender and prepare for trial. I need to emphasize this element of the law. There are no censures without a trial and without a harm to remedy. And I want to emphasize this because this is not the system we have. We have a system in which people are censured, especially in the form of fines, without trial and in the absence of any harm, proven in court, and furthermore, with a presumption of guilt, which the accused must overcome. I'm familiar with the story of a local builder who ran afoul of an OSHA regulation. The regulation required scaffolding for the construction of buildings, including residential buildings, which this one was. And this builder, out of ignorance of the regulations, did not erect the scaffolding. OSHA fined him $70,000, which drove him out of business. Now, one might say that the law is the law, and ignorance of the law is no excuse. As to ignorance of the law, only someone who has never seen the Code of Federal Regulations or the Federal Register can be serious about that. In his book, 3 Felonies a Day, attorney Harvey Silvergate claims the average American unknowingly breaks a minimum of 3 federal laws per day. There are now firms that specialize in going around to businesses, that pay them for the service, and these businesses perform OSHA-like inspections to help them protect themselves from OSHA. Now, I've placed a link in the description box to a photograph of just a few volumes of the Code of Federal Regulations. Now, many people familiar with the Mosaic Law like to point to a certain regulation requiring property owners to install parapets on their roofs as justification for the sort of detailed regulations we live under every day. And that's fine as far as it goes, but, as usually is the case when it comes to legal matters, there are some fine, though crucial distinctions to make. Let me read that regulation from Deuteronomy chapter 22, verse 8. When you build a new house, you shall make a parapet for your roof, so that you will not bring blood guilt for your bloodshed on your roof if anyone falls from it. Now, the first thing to take note of is that the only way someone could legitimately be on your roof is at your invitation. If someone, who would probably be an intruder intent upon stealing from goods commonly stored on roofs, is on your roof uninvited and falls off, his blood is on his own head, and you're not liable. But if, on the other hand, you invite someone up to your roof and he falls off, then you're liable for damages. The second thing to take note of is that the property owner is not censured simply for not having a parapet around his roof. No harm, no foul. And the third thing to notice is that this provision is intended to protect both the homeowner from liability and his guest from injury. And even if a property owner who did not build a parapet on his roof did invite someone up there, as long as no one falls off and injures himself, the property owner is not censured. There is nothing actionable if there's no injury. So getting back to that builder, as long as there was no harm to anyone, he should not have been fined and driven out of business, which, by the way, did not help his employees who were unemployed when that man lost his business. Before moving on, I need briefly to discuss the legal elephant in the room. Often, naysayers who enjoy mocking the law will accuse us of selectively applying the law, especially with regard to provisions such as that of eating shellfish, mixing textiles, and other restrictions. One thing that is overlooked is there are no penalties imposed upon violations of these provisions except the presentation of an offering intended to cleanse the offender from these unclean things. And that gets us to the purpose of these restrictions, which was to keep a hedge around the Hebrews by limiting their proximity to the uncircumcised in order to keep them from being soiled. These restrictions always came with the qualifier, unclean to you. The implication being they were not unclean to Gentiles. But we have more than that for an argument against the claim that we cherry pick, and that argument comes to us from Acts chapter 10, verses 9 through 16. Acts chapter 10 begins with a narration about a certain Roman centurion named Cornelius to whom an angel appeared in a vision and instructed him to send for the apostle Peter, who lived in Joppa. Now, on the day the messengers arrived, Peter had been up on his roof in prayer, but, quoting from chapter 10 now, he became angry, rather hungry, and wanted to eat, and he fell into a trance. He saw the sky opened up and an object like a great sheet coming down, lowered by four corners to the ground, and on it were all kinds of four-footed animals and crawling creatures of the earth and birds of the sky. A voice came to him, "Get up, Peter, kill and eat." But Peter said, "By no means, Lord, for I have never eaten any unholy or unclean thing." Again a voice came to him a second time, "What God has cleansed, no longer consider unholy." This happened 3 times, and immediately the object was taken up into the sky. This event in the life of Peter was significant. Had God not cleansed those unclean things, then Peter could not have visited Cornelius in his home. For as Peter told Cornelius, "You yourselves know that it is forbidden for a Jewish man to associate with or visit a foreigner, and yet God has shown me that I am not to call any person ungodly or unclean, and that is why I came without even raising any objection when I was sent for." Had God not lifted the cleanliness restrictions, the apostles could not have made disciples of the Gentiles. This, incidentally, is how the question of whether Gentile believers needed to be circumcised and made to keep the law was resolved in Acts chapter 15. With the restriction lifted, Peter could go into Cornelius' house and baptize him and his household, and Paul could be the missionary apostle to the Gentiles. This is why, in my episode on Christendom and the Great Commission, I insisted on the importance of teaching the law in the doing of evangelism. So to sum up the approach to jurisprudence of a reclaimed Christendom, the intent is not to make people holy, but to repair actual harms. If there are no actual harms, as demonstrated in the law courts, then there are no censures. I think this is important to point out because I happen to think the laws we find in Scripture actually allow for more freedom from government interference than one might expect from all the bad press the law gets, mostly from people who can do little more than copy and paste passages in efforts to demonstrate the horrors we should supposedly experience at the prospect of a reclaimed Christendom. But I do need to admit, there are no guarantees that people with my view of the law would be the majority report. That said, copy and paste theonomists have never been the majority report and likely never will be. And this issue of diversity of thought, just with regard to the application of the law, brings us to even greater, even much more contentious divisions. I mean the problem of schism, the idea of Christendom as a civilization with a supporting culture that, under the influence of traditional Christianity, orients its members toward the kingdom of heaven, suggests a unity that does not seem to exist. Traditional Christianity, this one thing that influences the culture in pointing people to Christ, is not actually, or so it seems, a single thing. And this raises the question, which version of this supposed traditional Christianity are we talking about? Well, beginning in the next episode, I will turn to a discussion in the broadest strokes of the divisions between the three largest Christian bodies, the Roman Catholic, the Eastern Orthodox, and the Protestant. There is diversity even in these three groups, so I will necessarily be talking in generalities. And the theme of this coming discussion will be rapprochement. What would it take? Thank you for listening.